Ladies and gentlemen, this is I am Hotep, Atum L. Um, I made a previous video about appealing a child support case, but it looks like the Court of Appeal is against the people. In my previous video, I explained that I was never served. And it's up to, since child support is the one saying that I did get served and I deny it, as a legal maxim saying that they should be able to prove that they served me. The Court of Appeal in California, 4th District, Division 1, dismissed my case based on no evidence. Basically, they dismissed it based on they don't want to deal with it. So I will read here the dismissal order. Let me zoom in a little bit so you guys can see this clearly. So it says, the court has received and considered the appellant's letter brief, filed on November 25th, 2016, regarding the timeliness of his appeal. The matter has been considered by Presiding Justice McConnell and Associate Justice Irion and O'Rourke, and the appeal is dismissed as untimely. So they basically, it sounds like they didn't really take what I said at all into consideration. So under the California rules, the rules of court, Rule 8.104A1, a notice of appeal must be filed on or before the earliest of 60 days after the Superior Court clerk serves the party filing the appeal with a notice of entry of judgment or filed endorsed copy of the judgment. B, 60 days after the party filing the notice of appeal serves or is served with a notice of entry of judgment or a file endorsed copy of the judgment. See, that never happened. So they didn't consider that. And C, 180 days after the entry of judgment. Under that rule, appellant was required to file his notice of appeal on or before May 31st, 2016, that's actually more than 160 days after December 1st, 2016. So they got their days wrong. Or 180 days after entry of December 1st, right, December 1st, 2015. Appellant's notice of appeal filed on October 6th is therefore untimely. That's because I never knew. To the extent appellant raises equitable arguments to overcome the appellant deadline, neither mistake, inadvertence, accident, misfortune, estoppel, nor waiver can afford relief from the jurisdictional necessity of filing a timely notice of appeal. Sharp versus Union Pacific, 8th volume, California Appellant, 4th edition, pages 357 and 361. There's error here. There's a definite error here. First of all, December 1st would be more than 160 days to May 31st. And they're saying they're saying B, the California Rule 8.104B, 60 days after the party filing a notice of appeal serves or is served with a notice of appeal. That never happened. Notice of appeal never happened. I never got that. So again, they're going against their own court rule here. Let me read the last paragraph. The time for appealing a judgment is jurisdictional. Once the deadline expires, the appellant has no power to entertain the appeal. And they noted a case here. The court is therefore without jurisdiction to consider the appeal. So basically what they're saying is they don't want to take the appeal because they even told on themselves right here, right? That I was served. If I said I wasn't served, I wasn't served. And there's no, and if they didn't produce any evidence to say that I was served, the onus is on the one who accuses, not the one who denies. So they're with error here. So I can take this probably to a federal appellate court or federal court now, since they said this and it wasn't true. Um, and then the thing that they wanted to back up, they put a court case here, right? And it's California appellant. So the fourth edition, 15 volume fourth edition, pages 51 and 56. So they approved what they wanted to approve, and they dismissed what they didn't want to see. Of course, the rule is still in effect here, but in effect only if due process is exercised, which it wasn't. So I consider this almost frivolous in my situation. So I'm very disappointed in the judicial system for siding with their buddies' child support. And there's nothing they can do to change my mind there. So actually, there's another rule, even after that was filed, to a notice of rehearing. All right, so I sent the letter in. It was only one page, very easy to decipher. And this is what they said about my notice of rehearing. The court has read and considered appellant's notice of rehearing due to extenuating circumstances filed on December 12, 2016. The court construes it as a motion to vacate the dismissal order filed on December 7, 2016, and to reinstate the appeal. Appellant does not set forth facts that would provide the court with jurisdiction to hear his untimely appeal. California Court Rules 8.104b. No court may extend the time to file a notice of appeal. For the same reason set forth in court order dismissing the appeal, appellant's motion is denied. So again, I tried to get a rehearing and it was denied. Shit, the only thing I could think of here is, they just don't want to hear it. They're sticking to this like glue. This rule right here, they're sticking to it like glue. But of course, this rule was written in accordance with what is it? Section Article 1, Section 9 of the California State Constitution. If I can type here, Section 1. Article. If I can type here, Article 1. Shit. What's wrong with me this morning? Article 1, Section 9. Let's see. No, not this one. Let's go back. We don't care about Annenberg's. Cornell usually has a lot of good stuff. So, let's see. The mitigation and importation of such person as any of the states now existing shall. No, there's no titles of nobility. Okay. No. Let's just look up. I should know that, but let's go due process clause. So this is the 5th and 14th Amendments. Let's look at Wikipedia. So the 5th and 14th Amendments to the U.S. Constitution each contain a due process clause. Due process deals with the administration of justice. and thus the Due Process Clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. The Supreme Court of the United States interprets the clauses more broadly because these clauses provide four protections: procedural due process, substantive due process, a prohibition against vague laws, and as the vehicle for the incorporation of the Bill of Rights. Due process ensures the rights and equality of all citizens. So, this is what the California Court of Appeals, which is an Article 3 court, did not want to deal with in my case. They had no interest in the incorporation of my Bill of Rights. So it seems like either I need to take it to a superior court, which is which would actually be taking a level lower than the Article 3 court, to be an Article 1 appeal, or I've already tried to take this case into federal court, but I didn't understand the federal question. So I'm probably going to go to the law library, do some research on the federal question, and try to move the jurisdiction. But even then, there's timelines. So I really don't know what I'm going to do there. But I'm working on not using the Social Security card, and actually I have my own business, which I'm trying to get up to speed. So I think that's the best solution right there, is the latter, just to get out of their system, stop being a slave, and just do my own thing, because working for somebody else is just, when you use that Social Security card, it's some bullshit. It's just bullshit. Uh, all brothers and sisters need to get out of that. You know, um, we all have the ability to generate our own income without working for someone else. So as soon as we learn that, we become, you become more godlike in your approach, and you'll be listening to the seven principles of Tahuti. You know what I'm saying? So, you know, I, let's see the laws that I remember offhand. I remember the principle of rhythm, the principle of polarity, the principle of gender. Um, that's four. There's three more principles I haven't memorized. Um, okay, yeah, I don't remember any more than that, but I'll update you guys on how this is all a spiritual process, man. You gotta learn patience. You gotta learn how to endure, and you gotta learn how to try to figure out what these motherfuckers are saying. You know what I'm saying? These motherfuckers is talking these legalese, and they understand exactly what I'm saying to these motherfuckers, but they don't want to give me my due process. It's like, oh, who does this nigga think he is? So in California, I guess it's a little tougher than other states, but I'm just doing what the law is allowing me to do, and I'm doing what God is allowing me to do. The El Kalum, the All, is allowing me to do. So man wants to try to shut me down, or woman wants to try to shut me down, but they're not the only game in town. So I just gotta do my due diligence, and hit these dudes where it hurts, which is basically running my own shit. But besides that, even if I do run my own shit, I'm still gonna um, get this taken care of. So I would never tell anybody that not to fight this. Keep fighting it. It's worth it. Keep fighting it, because these people do not want you to take them to court. They'll do anything. I have some I kind of have an idea or a suspicion that child support may have gotten to the Court of Appeals. That's how far I'm willing to take it. So, but they won't be able to get to a federal court, more than likely. So I need to try to get it back into a federal jurisdiction. With the timeline, they didn't let me. I didn't get served. So it's more of a fact that I told the appellate courts I didn't get served. I told them numerous times I didn't get served. They didn't listen. They didn't want, they didn't want to take heed to what I was saying, but they could not disprove what I was saying. So they could take child support's word for it, but the word isn't solid either without any proof. There's no proof beyond a reasonable doubt that I was served. And I'll stick to my story until they can prove to me that I'm wrong. So I'm just going to, I'll let you guys know where I take it from here. But it's kind of interesting how corrupt the even Article 3 courts are within the state. So I just want to let you guys know all this. The fight is not over. It's far from motherfucking over. We from Cali, nigga, we ride, and we ain't gonna stop riding till the justice is served. So we'll see what the fuck's happening with this. We'll see what's popping. The courts shall be open to every man for injury done to him, and in this case, the court was not open. The court was closed-minded, ignorant, and full of fucking shit. So the court can kiss my motherfucking ass. That's how I feel. But we'll take it a different route. This time I'll let you guys know. I know Amin's tried to help, but in this instance, he was unable to help. And so I'll have to take it into my own hands to try to get the motherfucking shit done. You know what I'm saying? So, again, here, my due process clause is supposed to be protected, but of course that did not happen. So, I got the letter. I was heated. When I first got the letter back, but I'm like, hey, what do you expect from a corrupt government? So it took me a couple of days to, kind of calm down, get my wits about me, and give it another shot. So anyway, give me a view, give me a like, man. Just trying to show you guys what I'm going through as far as this child support bullshit. They're scared. They do not want me to put this into court and give it a publication, but I'll try again. You know what I'm saying? I'll keep trying until we get it in the court, because once I get it in the court, I got them. Because they're not even following their own laws. So if I get them in the court, I'm going to win. But that's the tough part, getting in the court. So you know what I'm saying? Peace to the El Kalum, peace to the gods, peace to the Elohim, peace to everything it took to make me and make you viewing this video. And let's stick together. If you got any comments, leave them in the comments below the video. But besides that, I'm out. I gotta make this money, not for them, but for me. And I'll see you guys in the next video. Peace.